Hi everyone, my name is Kimberly and I'll be starting off this video by walking you through the offense of rape. First of all, Section 375 of the Malaysian Penal Code defines the offense of rape as sexual intercourse committed by a man with a woman under any of the circumstances listed in subsection A to G. And from this definition, we can extract a few elements. To begin with, the offender must be a man and the victim must be a woman. So legally, only men can commit rape and only women can be considered as rape victims. It is also important to note that the current legal framework only recognizes gender at birth. So theoretically, only individuals who are female at birth will be accorded legal protection against rape. In addition, explanation to Section 375 clearly outlines that penetration is sufficient in proving sexual intercourse, and it is not required to show a complete sexual intercourse. Given that the offenders and victims can only be men and women, the penetration must be a penetration of one's vagina with his penis. Furthermore, any slight degree of penetration will suffice, even involving the tip of the penis with the labia, which is the fold of skin around the vagina opening. It is also not necessary to prove ejaculation or a tear in the hymen. Also, although the presence of semen is a strong evidence of penetration, such evidence is not a must to prove the case. Moving on, rape must also occur under one of the 7 circumstances listed in the subsections A to G, and these circumstances can be generally categorized into 4 different segments. The first category is against her will under subsection A, and the second category is without her consent under subsection B. At this point, the difference between against her will and without her consent may not be apparent, and on this matter, the court has clarified that against her will indicates strong opposition or resistance by the victim, whereas the category of without her consent involves no physical resistance manifested by the victim. The victim may have decided not to consent, but she does not show any physical resistance and may not actively refuse or protest. Speaking of the second category, we can refer to Section 90 of the Penal Code for better understanding, and Section 375 subsection B does not define the term consent. Under Section 90, there are 3 situations where the Penal Code will consider the so-called consent as invalid or deemed not to have been given. Firstly, under subsection A, when a person consents due to fear of injury or misconception of fact, and the person doing the act knows or has reason to believe that the consent is given under such fear of misconception, the Penal Code will consider this consent as invalid. The offender's belief must be reasonable, meaning that an ordinary reasonable man would have also believed that the victim did consent to it. The court clarifies that a lack of resistance does not equate to consent. An offender cannot argue that the victim's failure to resist sexual intercourse leads him to reasonably believe that the victim has consented to it. Such an argument will not be accepted by the court. Secondly, under subsection B, consent given by someone who is of unsound mind or intoxicated and thus unable to understand the nature and consequence of the act they are giving consent to will not be recognized. Lastly, under subsection C, the so-called consent given by an individual who is below 12 years old is also invalid. The fourth category is when the victim is below the age of 16. This is a statutory rape, which is an act of sexual intercourse with a person under the age of consent. Under Section 375, subsection G, the age of consent is 16 years old, as it is believed that girls under 16 years old are not mature enough to consent to sexual intercourse. Note also that it is not a strict liability that the offender must know that the victim is below 16. The key element here is the age of the victim, and the words with or without consent indicates that as long as the victim is below 16 years old, the issue of consent is irrelevant. It is still rape even if the victim did consent to it. In short, girls and women must be aware that they have the right to say no to unwanted sexual intercourse, and the law is actually in place to protect them.
Regarding Section 375 subsection C to F, there is consent given by the victim, but the consent is considered to be invalidated. Under subsection C, consent is obtained under fear of death or hurt to the victim herself or others or misconception of fact. Hurt is defined under Section 319 of the Penal Code as bodily pain, disease, or infirmity. Here, the phrase to herself or any other person shows that the fear of death or hurt placed by the accused need not be exerted on the victim only, but can be on anyone. When it comes to misconception of fact, there is also a requirement on the part of the accused that the accused must have the knowledge or belief that the consent was given due to such misconception. In the case of Chu Nang Hong, the accused warned the victim that he would strangle her if she shouted with his hand putting over her neck. She remained still in the middle of the room and let the accused undress her and had sexual intercourse with her because she was so frightened. As there is fear of death, this consent is said to be invalidated. If a university student gives her consent to sexual intercourse when she has a misconception as to the fact, or even more serious when she is threatened to be killed or injured, the accused may be said to have committed rape as the consent is invalidated. Under subsection D, consent becomes invalid when the victim believes that the accused is her husband and the accused knows that he is not her husband, or when the victim believes that the accused is a man to whom she will consent, such as her boyfriend. The phrase to whom she will consent shows that it is not necessary for the particular person to be a man who she knows personally. In the case of Muhammad Taharuddin bin Harun, the victim thought the accused was her husband, who works at Kuala Lumpur and usually comes home once a month, but she felt someone sleeping beside her at 3 a.m. that night. The accused carried her to the bedroom and had sexual intercourse with her. She only then realized that the accused was not her husband when she touched his curly hair and the necklace on his neck, as her husband did not have the same. If a university student gives her consent by mistaken belief that the accused is her boyfriend or anyone she is admired to, such as her favorite actor, the consent given cannot be a valid consent. Next, under subsection E, there will be no valid consent if the consent is given at a time where the victim is unable to understand the nature and consequences of that to which she gives consent. Here is an example in the case of Muhammad Khairul bin Mat Razali, in which there was no resistance from the victim when she was raped by the accused, as she being mentally challenged and afraid of being harmed by him. Moving on, subsection F covers the consent given by the accused using his position of authority over the victim or because of professional relationship or other relationship of trust in relation to her. In the case of Augustine Fu Bujang, the accused was the master of the victim who was a maid. A position of dominance had been established by him over her as she was completely dependent on him financially. She did not resist as strongly as she should have expected to be. This might be because she was afraid of doing anything which might prejudice her position and her employment. Lastly, Section 79 of the Penal Code may be a possible defense for rape as suggested by the case of Teo Cheng An. Under Section 79, the accused must be either justified by law or by mistake of fact, in good faith, believe himself to be justified by law in doing so. An act or belief is not in good faith if it is done or believed with no due care and attention. The court seems to imply that as long as the accused could show that he mistakenly thought that the victim did give her consent to sexual intercourse, he can raise the defense. Nonetheless, the defense in this case failed and there are, to date, no cases to affirm the applicability of Section 79 as a defense of rape.
In Malaysia, the Penal Code addresses various sexual crimes, including specific provision for offences that occur within marriage. One such provision is Section 375A, which recognizes the gravity of violence or cautions within marital relationships. This provision addresses situations where a husband causes harm or instead fear of death in his wife to compel her into sexual intercourse. Such acts are considered criminal offences, punishable by up to 5 years of imprisonment. Introduced in 2007, Section 375A marked a significant step forward in acknowledging the existence of abuse within marriage. Section 375A is significant because it acknowledges that violence and cautions within marriage should not be tolerated. It makes it clear that the marital status does not grant a husband the right to violate his wife's autonomy. The law criminalized the use of force or threat to obtain sexual intercourse within a marriage, underscoring the importance of consent in intimate relationships. However, Section 375A has notable limitations. It only criminalizes marital rape when physical violence or the threat of death is involved, leaving many survivors without adequate protections in cases where cautions occur without such violence or threat. Furthermore, the penalties under these sections are more lighter compared to those for rape under Section 375, which carry a sentence of up to 20 years of imprisonment and whipping. This disparity raises concerns about equality before the law and undermines the pursuit of justice for victims of marital rape. Internationally, Malaysia has faced significant criticism for its reluctance to criminalize marital rape in full. Bodies such as the United Nations and the Conventions on the Limitations of All Forms of Discrimination Against Women, CEDAW, have called for reform to remove the marital rape exemptions and strengthen protections for survivors under laws like Section 375A. These recommendations stress that all individuals, regardless of their marital status, have the right to autonomy over their own bodies and to be protected from sexual violence. While Section 375A addresses cautions within marriage, further reform is necessary. The law should be expanded to criminalize marital rape in all instances, irrespective of physical violence or threat. Such a reform should align Malaysia's legal framework with international human rights standards and send a strong message that all forms of sexual violence within or outside of marriage are unacceptable. Moving on, gang rape is defined as an offense where one or more individuals acting with a common intention rape a woman. The punishment for gang rape is imprisonment for 10 to 30,000. The law emphasizes that all participants, whether directly involved or not, are equally responsible as long as they share the same common intention. As clarified in Priya Pauter and State of Madhya Pradesh, the acts may differ but must be driven by a common intent. These provisions ensures gang rape is punished more severely than individuals rape, recognizing the greater harm caused by multiple offenders. Section 376 Clause 2 of the Malaysian Penal Code imposes the heaviest punishments for aggravated rape, including 10 to 30 years, imprisonment and mandatory whipping. It protects vulnerable groups such as minors, pregnant women, and those with disability. The law emphasizes the importance of consent and addresses abuses or power dynamic in cases where authority is exploited. It also recognizes the physical and emotional impacts of rape, including trauma, suicide, and long-term mental health issues. These provisions aim to deter offenders, ensure justice, and promote victim support. True challenges in evidence and victim reluctance remain.
Hi, I'm Samantha and I'll now be walking through the punishment for rape. So under Section 376 subsection 1 of the Penal Code, those who committed rape will be punished with imprisonment to a term up to 20 years with whipping. Aside from that, Section 376 subsection 2, a punishment with imprisonment for a term between 10 to 30 years along with whipping can be imposed on those who committed rape under certain circumstances, such as causing hurt to the woman or another person, or puts the woman in fear of death or hurt to herself or any other person, and so on. Aside from that, a punishment of imprisonment for a term between 8 to 30 years with whipping not less than 10 strokes can be imposed upon the rapist who committed the offense under circumstances that he is not permitted to marry the woman under the law, religion, or custom. And this is also in line with the law of incest, which I will be covering on later on. Lastly, capital punishment or a punishment of imprisonment for a term between 15 to 30 years with whipping of no less than 10 strokes can be imposed on the rapist who causes the death of the woman. Incest essentially involves sexual abuse and abuse of power by a person who derives authority over the victim by virtue of blood relation. Under Section 376A of the PC, it states that a person commits incest when they engage in sexual relationships with another person who is not allowed to marry them under their own laws, religions, custom, or usage. This offense can be committed by the child, but a female under 16 and a male under 13 shall be deemed unable to consent and therefore have a defense to such a charge. Mohammed Zandre bin Arifin versus public prosecutor, the accused was found guilty of having sexual intercourse with his daughter. In correspondence to Section 376A, Section 376, subsection 3, entails the punishment for incest with imprisonment of a term not less than 8 years and not more than 30 years and shall also be punished with whipping of not less than 10 strokes. Why this is relevant to students is because there may be some people who went through this and are afraid of reporting their case due to social stigma. However, if they ever change their mind, they can still opt for a prosecution because in criminal cases, the statute of limitations sets the time limit for prosecuting an offense. However, for serious crimes like incest, there is generally no statute of limitations, meaning that charges can be filed even after many years. The availability and strength of evidence play a crucial role, as the longer the time since the alleged incident, the harder it may be to gather sufficient evidence to support a prosecution. Testimonial, physical evidence, and witnesses are often affected by time, and if someone wants to bring up an old case of incest, they will typically need to make a police report. The authorities will then investigate the claims and determine if there is enough evidence to bring charges. In insulting the modesty of a person, Section 509 defines that to insult somebody's modesty, uttering words, making sounds, or exhibiting objects may result in imprisonment, fines, or both. The penalty for this offense is up to 5 years in prison, a fine, or both. Sufyan bin Yusuf versus public prosecutor gives us an illustration. The accused presented himself as a police officer and had taken photos of the private parts of the victim and hence was charged. Another illustration is in the case of Maslinda Ishaq versus Muhammad Tahir Osman and others, where the first defendant was convicted under this section for taking photos of the victim when she was urinating.
Section 377A provided that any person who has sexual connection with another person by the introduction of the penis into the anus or mouth of the other person is said to commit carnal intercourse against the order of nature. The main key point in this section is the introduction of the penis into the anus or mouth. Hence, it needs to be considered that the issue of consent doesn't arise in this provision. Under the Penal Code, if it was anal intercourse or oral intercourse, it will not be considered as rape, but instead is a carnal intercourse against the course of nature. Along with Section 377B, it provides a penalty of up to 20 years imprisonment and whipping. In the case of Dato Sari Anwar Ibrahim, Azizan testified in court during the sodomy trial that Anwar had sodomized him up to 15 times at luxurious hotel and condominiums. Anwar denied any involvement with the matters, which was brought to court allegedly stained with his semen. Anwar was found guilty on August 8, 2000 and was sentenced to 9 years in prison for sodomy to be served consecutively with an early 6 years term for corruption. Sukma was sentenced to 6 years in jail. However, on September 5, 2004, Anwar won his appeal against the sodomy conviction. The judge ruled that Azizan's inconsistency and contradiction were unreliable sources, and Sukma's conviction was overturned. Section 377C, committing the carnal intercourse against the order of nature. However, this is committed without consent or against the will or by putting the other person in fear of death or hurt to the other person or any other person. This can be seen in the case of Chan Wan Chuan and PP case. The appellant was charged with rape and carnal intercourse without victim consent and sentenced to 10 years imprisonment and 2 strokes of whipping. This provision talking about acts of gross indecency with a penalty of up to 2 years imprisonment. The appellant Sukma Dumawan was charged with an offense of gross indecency under Section 377D of the Penal Code. He pleaded guilty and admitted the facts that were presented by the prosecution, which for allowing one Dato Sri Anwar Ibrahim to insert his penis into his anus. The accused appealed the Sessions Court's decision. The court allowed the appeal, quashed the conviction, set aside the sentence, and ordered a retrial. This provision provides that any object into the vagina or anus of the other person without the other person's consent with a penalty of not less than 5 years and whipping. The actus reus of this provision is any object or any part of the body except the penis into the vagina or anus of the other person. However, there is an exception under this provision, which is the medical or law enforcement purposes. This can be seen in the case of Munya, Eke Jalang, and PP case. The accused denied sexual intercourse with the victim, but DNA evidence showed that he and his fingers' laden semen were inserted into her vagina, in which causing the girl pregnant. The court held that rape cannot be induced by a finger insertion into a victim's vagina. To conclude, Section 377A and 377B prohibit carnal intercourse against the order of nature with a penalty of up to 20 years imprisonment and whipping. Section 377C, carnal intercourse without the consent of the other person or against the will of other person. However, Section 377D criminalizes acts of gross indecency with a penalty of up to 2 years imprisonment. Last but not least, Section 377CA introduced any object or any part of the body except penis into the vagina or anus of the other person without the other person's consent. Thank you.